Good afternoon, Judge. Attorney Tim Hendricks for Miss Collins.
Let me try to find this. It's gonna. Okay. This is a motion concerning the first issue is the cancellation of Kentucky K-chip, I guess it's called, and what's the explanation for that?
Judge, my understanding is that Miss Collins does not
You're
reside
gonna
in
have to look
Kentucky.
you're gonna have to look, I can't hear you, you're gonna have to turn it up or something.
Sorry, Judge, my understanding is that Miss Collins no longer resides in Kentucky. She has moved, she's lived in Tennessee for several years. And so when she uh, applies for those type of things, she has to do it in Tennessee. My understanding is she did not request that they transfer for the child for his card to go to Tennessee, but that's just simply what they did when she had to update her information a couple years ago. My understanding is this card change has been in effect for several years.
You're gonna have to, I'm gonna have to get some earphones or something. I can't, you give me some earphones. Can you hear what he's saying out there?
I cannot, Judge.
Okay, we'll get some earphones out there.
And it's we got her right here also.
Now try to say something.
Yes, sir. Maybe that'll cut down on the echo. Judge, my understanding is that the card change has been in effect for several years. Miss Collins, several years ago, resided in Kentucky, and that's where the card was through when she was a resident of Kentucky. However, for the last several years, she has been a resident in Tennessee. And so that's where she has to make her application for that type of relief.
Where is it? Where is the child in school? Here or?
Here, Judge.
Yes, sir. I believe it's here.
I would think that, to kind of advance this thing, it would appear to me that the child resides here more than the child resides in Tennessee. And here is where the medical card should be, because if there are providers here, you got networks and stuff with TennCare, and TennCare is, from my old days in the legislature, is not, the coverage in TennCare is not as expansive as the coverage in Tennessee. Is that correct?
That is correct, Judge. And then also, Miss Collins was a resident when this case, before there was a final ruling in this case, she was a resident of Tennessee. This child has always had a medical card here in Kentucky. The order specifically says the parents are to maintain that, not to unilaterally go and change it. And that child, all the providers are here in Kentucky who do not accept TennCare.
Yeah, we're not, you don't have a response for that, Mr. Hendricks?
Yes, sir. My understanding is she did not seek to change the card. It was changed when her information was updated to Tennessee. She can't come in.
Well, why was she given information to Tennessee? I mean, if you say that you're a Tennessee resident and the child is a Tennessee resident, then they're going to update. But what was
Judge,
go ahead.
yes, sir, because she had to update her own information so that she could get her own health care there. My understanding is she does not have private insurance. So if she also wanted to have benefits for her to cover her, she had to update her information. And the order requires the medical card to go either through her or the father, and the father has been incarcerated. So if she's tied to the child and she has to update her information so she can have coverage, then that seems to be what the mechanism was.
Judge, that's not totally.
Speak louder.
That is totally inaccurate. She contacted my client the end of October asking to see a copy of his medical card. My client complied as a joint custodian by providing her a copy of that. She took the child to the doctor, my client did, for an illness, and she discovered then that his medical card had been canceled. And specifically, the order that was entered on February the 15th of 2019 says that my client is the primary residential custodian and that this child goes to school in Kentucky. So I don't know how we interpret that in the last 6 years to mean that she's the one that carries the medical card. How does she list this child suddenly?
Yeah.
Because
Okay,
you
what do
have
you
to
have to say
update.
about that, Ms. Hughes?
Judge, your order specifically charges the mother and the father to maintain the child's medical card. The
Judge-
father is incarcerated, so cannot.
Well,
So
I
that
know the
leaves
father is incarcerated, but what
right.
Ms. Rose is the primary custodian.
Yes, sir.
Maintain, Judge, not to obtain a medical card for the child, to maintain the child's existing medical card, which was, the child was still eligible because he's a resident of Kentucky with my client. We didn't suddenly just have an update in the last 6 years of his eligibility for Medicaid. This happened as soon as she got a copy of the card, Judge.
And that is not my understanding of what happened. My
I've got
understanding,
copies from Kentucky showing when it stopped.
Well,
I've not seen those, Judge.
well, they'll be provided to you. She'll provide them to you. I just think I don't know whether it was intentional or unintentional, but I think this is a terrible imposition on the custodial parent or the Miss Rose, who has equal and as a third party respondent in this case is a custodial. I just think that this child ought to have a Kentucky card and that TennCare ought to be informed that the child resides primarily in Tennessee. And I just think that's what the orders say. And talking about maintaining them. And if anything, Ms. Collins violated the order by interfering with the maintenance of health insurance here in Kentucky. And I will tell you that the Kentucky K-CHIP is a more robust coverage than TennCare. And now you got all the providers up here where the child is and goes to school all the time that won't take it. And I would say that those Tennessee providers down there would be glad to get a K-CHIP card from up here. I don't know what the reciprocity is. You know what reciprocity is?
Judge, I don't think they accept it because the providers
They
are
won't
not
take
within,
K-CHIP.
their providers are not within the network.
So you don't think the Tennessee providers will take K-CHIP?
No.
Well, they take out of network. K-CHIP is, in my experience, takes out.
And I guess it's dependent upon the provider.
Yeah,
if they're
okay,
gonna
what's
accept
the
it.
other issue?
Well, Judge, one thing just to clarify on that, my client's been in contact with Kentucky, and unless Ms. Collins is ordered to change that information, they will not change it back to Kentucky.
She is ordered
All
to
right,
change
thank
the
you. I'll submit an
information.
order that says.
There's gonna be an order. Now, what's the other issue?
The other issue is my client has asked to be able to declare the child as a dependent on her taxes because she's been primarily providing for this child. She's been covering if there was any uncovered expenses like over-the-counter medications and things. And so we're just asking.
How frequently is the child with Ms. Collins? Well, you want to swear her in?
Yes, I would ask.
Raise your right hand. Do you want to swear the testimony that God gives the truth, whole truth, nothing but the truth?
I do.
Okay, state your name.
Sherry Rose.
Okay.
She has Waylon on every other weekend except the last weekend of the month, which is mine. However, since Nathan is not available, I have his time as ordered by you. So she gets him again on December the 25th.
I'm just talking about.
Just in general.
In general, she has him from Thursday to Sunday, 2 weekends a month. Thursday till Monday morning, 2 weekends a month.
Okay. Ms. Hendricks, you want to question her about that?
I have no questions, Judge.
Okay, well, I'm gonna rule it that Ms. Rose does get the tax benefit. Is she eligible for the the federal tax benefits on the thing as far as the child?
I would think that she would be because the child is listed as a resident of her home and that
Yeah.
she has him a majority of the.
And Judge, just for the record, and I'm not sure it matters. The Kentucky Supreme Court has said family courts don't have jurisdiction to award that. They can affirm an agreement but that the parties are to follow the IRS. I don't think it will matter, but just for the record, because I think under the IRS, whoever has a child most has the right to claim the
And that is
child.
correct,
But
Judge. We just didn't want a contempt motion filed against us because we weren't following the court's order. So we wanted to come to the court
Well,
to
I
make
guess
sure
you
the
put in
record was
order
clean.
that the court has made findings that the child primarily lives with her, and that order could be submitted as part of any claim or IRS record. I think you're correct that I can't, although the federal courts quite frequently direct us things, unless we go into,
And Judge, is there a timeline on when she needs to go to get the Medicaid reinstated?
within 5 days,
Within 5
5
days.
business days. Okay, is there anything else?
Of course, we had requested attorney's
I'm
fees
not
based on
gonna
this
award
motion.
attorney's fees, because I'm not gonna award you attorney's fees because I don't have any proof up to this juncture that she didn't have any malintent or something, so I don't have that. I'm not gonna award attorney's fees.
Thank you, Judge. I think that's all that I'm going.
Thank y'all very much.
thank you. Have a good day.
Your Honor, I've not had the pleasure of appearing before you before, so is there a preference on which side you'd like me to stand on? Okay.
Side of justice.
Well, this looks like the side of justice.
Usually people just swap back and forth here because the camera's voice activated.
Understood.
Now, this is a motion to compel. As far as a check is concerned, and I read the, and you want there to be an itemization of costs involved.
Correct, Judge, we would like to see receipts of some sort, something that indicates the funds were actually spent on marital residence, improving or repairing the damage. I did receive by email this morning. I really haven't had a chance to do more than glance at it, but about 9:30 this morning, I got an affidavit, I think, from the other parties, from Mr. Page, and based on that affidavit, I feel we're gonna have to have an evidentiary hearing. It looks like he just indicated he had paid cash for everything. So I don't know that, I think that means no receipts would be forthcoming. Included in those were $1,500 to himself for labor, $1,500 to 4 other people who I don't even know who they are, they're relatives, they share the last name, some of them do. So I think that I haven't had a chance to
If you
research.
cut
or
out
look into it.
everybody out in Monroe County shares last names, there's not gonna be anybody left to do any work, What's your position? Now, this was a insurance settlement check. What responsibility you think your client has to prove that it was spent on repairing a property that was insured, and should there be any split of anything that wasn't used for that?
Sure, Judge. So this, just a little quick backstory. So there was a property, I'll be quick, I promise.
That's okay, I've got plenty of time.
On the property, there were 2 smaller building, larger building, and a roof. All 3 were damaged in a storm. This insurance check is to cover the repairs of those. The repairs that we listed in the affidavit are those that Mr. Page elected to do himself because it was necessary. He did pay cash. There aren't receipts available. I think the total of all that he spent was for $8,681.13. So it's our position that since he paid that out, that those will be released to him. The rest of that check, which is about $20,000 and some change, we would be fine with that going into one of our escrow accounts for us to then be able to go trace back. As for the property, the house itself, I think, is marital because I believe the parties built that together, Your Honor. However, Mr. Page does have a non-marital claim to the property that it sits on. Of course, that's more complicated than we need to get in today, Judge. So I agree that some of it probably needs to be split. And that's
How
why I
much
would,
money will your client take?
Judge, we haven't even had that discussion, as I
Well,
said.
it's always good to come with some authority to settle
Like I said,
things.
until I saw receipts, I mean, I got that this
I
morning, I
understand.
had no idea that was even coming, I
Well,
hadn't even done that math.
I
But like I said, I
have
know
no
at least
reason to-
4,500 of it was supposed to.
I have no reason to disbelieve any affidavit, but wait, let me finish. It's good. You're gonna like what I say, okay? I have no reason to challenge because you hadn't had an opportunity to cross-examine. But it would appear to me that if we get into a situation where someone's claiming insurance receipts predicated on work they did themselves, that it's a slippery slope that, they says he didn't, she says she doesn't know, so he could get the whole amount that way. So, I would think that you need to get receipts. Okay, and then also, if the check is for a certain amount, you need to say how much was that was for the outbuildings and how much of that was for the house, what damage. I was sure is, it doesn't, the only thing I got is a copy of the check.
Sure. And Judge, we've made a fervent effort to obtain receipts thus far. That's why the affidavit was filed this morning, because we would have liked to have.
He's gonna get some time. I'm gonna give him some time. Okay. We're gonna be back here on January the 22nd. And let's say by January the 15th, you get a detailed receipt situation to Ms. Coleman concerning where the money was spent. Do we have larger issues as far as property that needs to be settled rather than just focus on this? And if that's the case, I would probably want to just throw this all in a pile here. And as we did offsets and things like that, on the other personal property that is involved, and you say that there's a complication on whether the house is located on land that she doesn't have any marital interest in. I mean, I'd like, have you deposed everybody in this case, or you waiting to try it, or what are you gonna do?
We have not done depositions. I will say it was maybe 2 weeks ago that I got the second set of interrogatories answered from their side. So the discovery is actively being exchanged.
Okay, well, let's just include, instead of, have that portion of the discovery finished by the date I gave you previously, okay? And then you can decide whether you need to take depositions or whether you're gonna try the case. I'm not really in a habit of counting spoons and going down through all the sort of things that I'm not gonna do that, okay? Unless you absolutely make me do it, and then I'll be in a very foul mood if I have to do that, you know? So this is sort of thing, it doesn't seem to me to be that much money involved in the whole scheme of things here. And at some juncture, after you get this information, I would think it would be in everybody's benefit just to make a dollar offer and see if that was acceptable to people, rather than going down through that sort of thing, okay? Okay,
Just I
is
also
there
have-
anything else?
I also had a motion asking the court to bifurcate the action.
I don't see anything, I don't think these people need to be married to each other, so I will bifurcate it, give them both a decree.
Okay, so I can
Just
submit
submit
that
that
then.
electronically,
I will do that, Judge.
We have no objection to that, Your Honor.
okay. Okay. Yeah, okay, that'll be
So you
fine.
want us back here on the 22nd then, Judge?
Well, I tell you, when you get that information, you just determine, I would think it probably, since you had no deeper in discovery, that you probably don't need to be here unless you tell me that you've got an agreement, which I'll be glad to hear.
Okay,
But that gives you enough days when you receive this to file another motion to have it done with more particularity.
sure.
Does that make sense?
Yes.
So just
Okay.
to clarify, Judge, you want all of that done by the 15th.
That's right. And I will tell you that I appreciate people that have a skill set to do things, but I doubt very seriously whether somebody's gonna be able to collect for labor they did themselves on property like that. I don't think that would, the appellate court would look at that. Because it's the sort of thing that you can't determine with any certainty, you know? Okay, thank you very much.
Thank you, Judge.
Merry Christmas to everybody.
Merry Christmas, Judge. Nice to meet you.
Good seeing you. Okay.